Good morning, friends. My today topic is writ of habeas corpus. I am going into detail about the contouring of writ of habeas corpus. Friends, the writ of habeas corpus is a cornerstone of personal liberty and one of the most important constitutional remedies available in India. It is a legal instrument used to secure the release of person unlawfully detained or imprisoned, ensuring protection of fundamental rights granted under the Constitution of India. The term habeas corpus is a Latin expression meaning to have the body, which refers to the requirement that person detained be brought before a court for legal scrutiny of the detention. This right is crucial for safeguarding an individual's rights to life and liberty granted under Article 21 of the Indian Constitution, making it an integral part of country's legal system. In India, the writ of habeas corpus can be issued by the Supreme Court under Article 32 and by the High Courts under Article 226. This legal remedy ensures that no person is deprived of their liberty without proper legal justification. So, friends, I am going into detail. As already told, the term habeas corpus literally means to have the body of. It commands the detaining authority to produce the detained person before the court and justify the legality of the detention. If the court finds no valid legal reason for the detention, it orders the immediate release of the individual. Friends, in our constitution, every provision has some historical background. So I am also going into the concept of habeas corpus. It can be traced back to English law, first formalized in the Magna Carta of 1215 and later reinforced through Habeas Corpus Act of 1679 in England. The writ became a powerful tool to protect individuals against arbitrary detention by the state. The writ of corpus was incorporated in India into the constitution after independence, ensuring protection against unlawful detention and upholding the fundamental rights of the individual. If we go dive into our constitution, the Constitution of India empowers the judiciary to issue writs, including the writ of habeas corpus, under two key provisions. First one is Article 32 of the Constitution of India. Article 32 guarantees the right to move the Supreme Court for the enforcement of fundamental rights. It says that the right to move the Supreme Court by appropriate proceedings for the enforcement of rights conferred by this part is granted. Honorable Supreme Court can issue writs, including habeas corpus, to safeguard fundamental rights. As per our forefather, Dr. B.R. Ambedkar, Article 32 is often referred to as the heart and soul of the Indian Constitution. Then comes the turn of High Courts under Article 226. Under Article 226, the High Courts have the power to issue writs, including habeas corpus, not only for the enforcement of fundamental rights, but also for any other legal purpose. So, this provision gives broader jurisdiction to High Courts compared to the Supreme Court. So if we go by the differences between the two provisions, if the Article 32 is limited to fundamental rights, Article 2 to 6 allows high courts to issue writs for both fundamental rights as well as for legal rights. Now, every writ has some purpose. Similarly, the purpose of writ of habeas corpus is primarily the purpose is to ensure that no individual is unlawfully detained. So it protects personal liberty, firstly by requiring legal justification. It asks the detaining authority to provide valid legal grounds for the detention. Secondly, immediate release. If court finds no legal grounds, the court orders the release of the detained person, safeguarding fundamental rights. This writ protects Article 21, which talks about right to life and liberty and ensures judicial scrutiny of state action, further preventing misuse of power. It serves as a check against arbitrary detention by the executive or judicial authorities. So, friends, there are few of the circumstances under which we can file habeas corpus petition. First one is illegal detention. Second one is unlawful arrest. Third one is detention beyond authorized period. Fourth one is violation of court orders. Fifth one is preventive detention. Sometimes preventive detention laws are misused or are not adhered to. And last but not the least, detention without evidence. When there is insufficient cause or evidence for detention, one should not be detained. I am giving you an example. If a police officer detains a person without a warrant and fails to produce the person before the magistrate within 24 hours, excluding the distance of travel, the family or any person on behalf of the detainee can file a habeas corpus petition. Now, who can file a habeas corpus petition? I am going to discuss. Firstly, the detainee. This provision, this is rarely used. A detainee is in custody. How he will come forward to file this petition? Family members or friends, organizations or activists. Now, there are grounds for refusal of habeas corpus too. First comes lack of jurisdiction. If the court lacks territorial jurisdiction over the detaining authority, it can't issue it. Lawful detention. Pending judicial proceedings. If the detention is based on a valid court order, pending judicial proceedings, then writ of habeas corpus will not work. Detainee already released. He is no longer in custody. Defects removed. If there are procedural errors in detention and they are rectified, then habeas corpus will not work. Emergency situation. I am talking about pre 44th Amendment. During emergency, certain laws were suspended. So writ of habeas corpus could not work in that time. If we go by the features of the habeas corpus, it is procedural writ. Why? It acts as a procedural safeguard against unlawful detention. Second feature is it is speedy remedy. This writ ensures prompt judicial intervention. Locus standi relaxed, as any person can file the petition on behalf of the detainee. Judicial scrutiny. This writ examines the grounds and legality of detention, not limited to fundamental rights. High Court can issue writs for legal rights as well. Now, there are important case laws on habeas corpus. The important one being ADM Jabalpur versus Shivkant Shukla of 1976. In this case, no relief was provided. This case is also known as habeas corpus case. It was filed during emergency when the Indian government suspended fundamental rights, including the right to life and personal liberty under Article 21. Several individuals were detained without trial, prompting petitions for the writ of habeas corpus. But the Honorable Supreme Court held that during a state of emergency, individual could not approach the courts for the writ of habeas corpus as the enforcement of fundamental right was suspended. No doubt this decision received severe criticism for undermining constitutional freedoms and is considered a low point in Indian judiciary. We can say the in spite of the provisions in the constitution, our courts shackled them with the little interpretation of the provisions. Then comes Sheila Barse versus State of Maharashtra, that is of 1983. Sheila Barse is a journalist and human rights activist filed a petition concerning the ill treatment and custodial violence against women prisoners in jail. Honorable Supreme Court in this case broadened the concept of locus standi, enabling public spirited individuals to seek justice for vulnerable groups. We can say in this period, our judiciary came out of the shackles. They broke down the shackles and started broadening the meaning of the constitutional provisions. That's why the concept of local standi was broadened and public spirited persons were allowed to file petitions to seek justice for vulnerable groups. There comes a third case, Sunil Batra versus Delhi Administration of 1980. In this case, inhuman treatment of prisoners in jail, particularly custodian torture and harassment, was addressed. In this case, our Honorable Supreme Court expanded the scope of writ of habeas corpus, holding that it could be invoked not only to challenge wrongful detention, but also to ensure human treatment of prisoners. So, in this case, the court recognized that fundamental rights, including dignity, cannot be denied even to individuals under lawful custody. Then comes the case of Neelavati Behera versus State of Orissa, 1993. In this case, the petitioner's son was taken into police custody for interrogation and was later found dead on the railway track. So, in this case, the Honorable Supreme Court awarded monetary compensation to the petitioner for the violation of her son's fundamental rights. So, this case affirmed the habeas corpus can serve as a remedy for redressal of violation of Article 21, that is right to life and personal liberty, and extending the writ scope to include compensation for custodian deaths. Then comes Rudal Shah versus State of Bihar, 1983. This Rudal Shah was illegally detained for over 20 14 years, even after being acquitted by the court. What a sad story of our Indian government of that time. Honorable Supreme Court ordered the state to pay compensation for the illegal detention, establishing that habeas corpus can go beyond the release to provide monetary relief for fundamental rights violation. So this judgment marked a shift toward compensatory jurisprudence in India. Then comes the case of Kanu Sanyal versus District Magistrate Darjeeling. This case is no doubt older one, that is of 1974. In this case was focus was on procedural nature of the writ of habeas corpus. The court ruled that primary focus of the writ of habeas corpus should be on examining the legality of detention rather than merely producing the detained person in court. So this judgment ensured a substantive analysis of the detention process, emphasizing the importance of the due process of law. Now, let us little bit compare in few lines habeas corpus and preventive detention. Preventive detention involves detaining a person to prevent potential offenses. While preventive detention laws are constitutionally valid under Article 22, what I can say or the past experience says, they are often misused. So, friends, this writ of habeas corpus serves as a safeguard to ensure that preventive detention is not arbitrary and follows due process. Courts scrutinize whether the conditions for preventive detention are met, ensuring protection of fundamental rights. So, this is all about this topic. I am giving rest to my words. Enjoy your day.